Welcome back to the second paper of our first panel on Constitution Day. Having introduced Professor Blasi and his paper at the beginning, I'll say nothing, and so without further ado, Professor Blasi.
Thank you. It's really a great honor to be here. What I want to do today is to talk about perhaps the most criticized and the most praised of last term's decisions from the Supreme Court, the Federal Election Committee versus Citizens United. And that is the case in which the court held that the long-standing prohibition on the use by corporations and labor unions of their treasury funds in support or opposition to candidates within the time frame shortly before the election violates the First Amendment. The corporations and labor unions are allowed to set up political action committees and solicit contributions to those political action committees from their shareholders and employees and union members. Now they are also allowed to use funds that they have accumulated through other mechanisms, their general treasury funds, in support or opposition to candidates. They not yet, and I underscore that, are able to use those funds to make direct contributions to candidates, though there are many who think the other shoe will drop. But here we're only talking about independent expenditures, but the long-standing prohibition on that has now been declared unconstitutional by the Citizens United decision. The Supreme Court decision had some very vigorous disagreement. It was a 5-4 decision, and the opinions are lengthy and passionate and deeply informed and pretty exciting. And what I want to do today is to identify what I consider the 7 most important points of conflict, or where the dissent and majority opinion joined issue, and then try to adjudicate, if I can use that term, those disputes by trying to draw upon the thought of James Madison. So the way I'll proceed is to first identify the 7 points of conflict. Then I will offer a brief narrative of what I take to be an evolution in Madison's thought, although I've been chastened, I think, by reading Professor Sheehan's great book, which was published last year, into backing off a little bit from my previous views in terms of just how great an evolution that was. I still think there's something of an evolution, but I want to look at 3 eras in the development of Madison's thought, and then come back to the 7 points of disagreement and ask whether the evolution of Madison's thought has anything to say about those points of disagreement. The first point is that the claim by the majority that the core of the First Amendment is speech about elections. And because the case involved a limitation on speech about elections, it must operate under the strongest possible presumption, burden of persuasion, or presumption of unconstitutionality, or level of strict scrutiny, however you want to phrase it. But there's no kind of speech that will be looked at more, with more closely and with a higher burden of justification than speech about elections. Now, and because this is the regulation of election speech, the majority says it's a very demanding standard. The dissent does not disagree on the first point, that is that speech about elections is at the core of the First Amendment, but develops a somewhat different conclusion from that. That is, because it is so important that elections be fair, there is a role for the regulation of speech in elections. One example would be prohibitions on electioneering in close physical proximity to the voting booth. A restriction upheld earlier by the Supreme Court. Another example is the long-standing prohibition on government civil servants taking an actively engaged in the election campaign. So that there is somewhat of a history of regulating speech surrounding elections in service of a larger objective of conducting elections. And the dissent believes, therefore, that the thumb on the scale, so to speak, that the majority place is not quite right, even though speech about elections is at the core of the First Amendment. The second point of disagreement is, how important is it that corporations and labor unions can still speak through political action committees? Should we think of this as a total ban or something like a prior restraint? The majority, I think, very effectively conveys how much bureaucratic regulation there is of political action committees and how time-consuming it can be, and all the onerous record-keeping demands, and suggesting this has the kind of flavor of a prior restraint, that you have to do an awful lot of begging and record-keeping and getting permission, just to speak on elections. So shouldn't we look at this as something like Tudor-Stuart licensing and very presumptively invalid? The majority says nonsense. This is a time, manner, place restriction. You can still speak. It's not a total ban. And so we shouldn't look at it as so problematic, and certainly shouldn't think of it in terms of prior restraint. A third point of disagreement is the majority says this is this is an especially problematic law in that it draws a differentiation in terms of prohibition based on the identity of the speaker. It singles out disfavored speakers, corporations, and labor unions. And just as we have a principle against discrimination in the regulation of speech based on the speaker's viewpoint, and we have somewhat of a milder principle against differentiation based on the content of the speech, the topic, subject matter of the speech, there also is a First Amendment privilege that looks askance at differentiations based on the identity of the speaker. The dissent joins issue with that and says it's not the same thing, that there is a strong principle against viewpoint discrimination. There's a long history of differentiating based on the identity of the speaker. You don't have to look beyond the election context to see that. Back to my example about civil servants. They are singled out for a prohibition on engaging in electioneering speech. The identity of the speaker is the key. School children, prisoners, persons serving in the armed forces, lawyers representing clients. There are any number of disfavored speakers, if you want to call it that, where the regulation is a function of the identity of the speaker. Fourth, Justice Stevens makes much of the point that essentially picking up an old fight with Justice Scalia, but I think it weaves its way into this dispute. Are these kinds of prohibitions problematic because they favor incumbents? The conventional public choice theory of wisdom would be that who would ever pass a prohibition, any kind of regulation of campaign funding and spending? It's going to be passed by incumbents. And you can probably bet that they're not going to pass anything that's going to hurt their own prospects in the election. So we ought to presume that regulations of campaign spending are pro-incumbent in their impact. Justice Stevens sees fit to go into quite a bit of length trying to answer that. And there have been a fair number of studies in terms of who gets the money in contributions and who spends the most money in election campaigns and so forth. And there have been several recent studies on this issue of do campaign spending limits by different measures favor incumbents or favor challengers. But that's a key point of disagreement as to exactly who benefits from these. And of course, implicit is, should it matter? A fifth point of contest or dispute is the majority, and this is a theme that has, I think, in recent years grown in its significance in First Amendment, both theory and doctrine. The majority makes much of the point that we should look at this law as problematic simply because it reduces the total volume of speech. More is always better under the First Amendment, and any law which predictably, directly, will just reduce the total volume is in tension with the First Amendment. And I think the dissent is not inclined to give nearly so much weight to that effect, and inclined to give much more weight to the possible impact of these laws on the distribution of communicative opportunity or communicative impact. The majority opinion, the sixth point, is that the majority, how should I put it, is not impressed with the concern voiced by the dissent that the special capacities of corporations and unions to generate large amounts of money and thus large amounts of speech if they can use their treasury funds, it's likely to have a distorting effect. It's going to change the balance of speaking, and it's going to wind up making elections poorer measures of the will of the people. It's going to distort elections by virtue of the imbalance that will be introduced by having this new source of funds. What the majority says is that's paternalistic to worry about that. You have to trust listeners, that they may hear much more on one side of an issue than another because of the injection of these funds, but the final judgment is the listeners, and it's probably paternalistic to believe that they're going to be just as gullible as the dissent seems to assume. And finally, a factor that the dissent, this is Justice Stevens when I'm talking about the dissent all along, seems to give quite a bit of weight to, is that this really is going to have a very bad effect in terms of citizen morale or citizen sense of empowerment. The ordinary citizens who don't have access to this kind of wealth in the political process, to see these sources of funds having increasing larger roles in elections is going to be dispiriting in a way that may even be constitutional significance. And the majority, once again, I think, says that our citizens are made of sterner stuff than that, and they'll find ways to nevertheless trust their officials and engage in political combat, so to speak. And also, Justice Kennedy has a imaginative argument which might be described the theory of the discrete and insular corporation. And that is that Kennedy kind of gets out the violin and says that, the big corporations are going to find a way anyway. They're going to have their inside beltway obvious connections. So it's the small, struggling corporation that all of a sudden now can go to the general public and use their treasury funds to, combat the influence of the big bad corporations that are going to have the influence anyway. So you can see that there are lots of points of disagreement in the Citizens United opinion. Now, I would say that when you get beyond this analytical breaking down, there is a spirit, if we can use that term, to this opinion that I think it's in some ways the culmination of something I've watched in my lifetime. This is my 44th year of teaching and writing about the First Amendment. And there are obviously things to be irritated about, realizing that, but it's also, it's a wonderful, I'm finding at least, it's a wonderful advantage to have lived through so long an arc of doctrinal developing. I think it really does. It's just been really interesting to watch things play out from the early years when I was teaching the subject. And I would say that this is the ultimate playing out of, I think, maybe the three most important themes in the development of First Amendment doctrine that I've seen since I've been teaching the subject. And they are the increasing importance of this no viewpoint discrimination is the heart of the First Amendment idea. The increasing importance of the more is always better assumption. And the increasing importance of the anti-paternalism principle, that you just simply have to trust listeners. And even more deeply than that, there is what I would call something like the speech as such movement. And that is, the deepest logic of the majority is, you know, we shouldn't think about this in terms of predicting the effects, trying to decide how this fits into some larger theory of fair elections or republican government or citizen engagement. That's getting too complicated. It's just speech. And the First Amendment is pretty straightforward. It just tells you that you shouldn't regulate speech. And I think that kind of raw idea is a great deal more powerful today than I think it was when I began teaching the subject. Now, you might describe that to an increasing preference for what constitutional theorists, of which I wouldn't say I'm one, call textualism. Although often this idea is put forth as though the text read, Congress shall make no law regulating speech. When in fact the text, as you know, says Congress shall make no law abridging the freedom of speech, which then directs your attention to what is that freedom and what does it mean that it be abridged or not be abridged. The first thing I do in my First Amendment class every year is to write out the text of the First Amendment on the board and ask the students to identify what's the single most important word. And almost nobody gets what I take to be the right answer. The. And anyway, so, but this Citizens United, I think, is very much it's just simple. This is speech, you don't limit speech. Anyway. Now, why should I want to think about these issues with Madison in mind? Many reasons, but the most important is that it fits perfectly with my own personal intellectual agenda. I can give you originalist reasons. I can argue, which I believe, that even a person who believes in a living constitution should care a lot about what Madison thought. He's probably the wisest person who ever thought about these issues, and a living constitutionalist should want to draw on that wisdom. But to be honest, I've spent the last 20 years of my life attempting to understand the thought of the 7 people I regard as the most important contributors to the Anglo-American understanding of the freedom of speech. John Milton, James Madison, John Stuart Mill, Leonard Hand, Oliver Wendell Holmes, Louis Brandeis, and Alexander Meiklejohn. And I teach a history of ideas course in which I devote 2 weeks to parsing very closely their canonical texts. And I've written on each of these people, and I spent 89% of my professional time reading about these people. And it's just been a wonderful turn in my career, I believe, at least certainly for my own personal happiness. And one of the advantages of this is that it gives me the satisfactions of the intellectual grouping. Because with very few exceptions, maybe Meiklejohn's an exception, there is just, Leonard Hand, I guess, would be the other exception, but except for those two, there is just a rich, rich academic literature on each of these other people, and to have made a career out of just trying to get to know these people with such wonderful resources to draw upon to try to get to know these people. It's been wonderful. When Robert Miller called me and asked me to participate about a year ago, the first question I had for him is, well, this is at Villanova. Oh, well, by any chance, do you know Colleen Sheehan? Of course, I didn't know that she was the head of the Ryan Center. I didn't know she had anything to do with this event. He said, well, yes, as a matter of fact, I have met her. but I do regard Professor Sheehan as the leading Madison scholar in the world. And on my short list, I've got my intellectual heroes, Alan Ryan and John Skorupski on Mill, Tom Gray and David Luban on Holmes, but I could give you my Arthur Barker, who wrote in the 1940s on Milton.
His honorarium is doubled.
But I was a great fan of Lance Banning, who sadly passed away, I think, 3 years ago. But I've long considered Lance Banning and Colleen Sheehan the two great Madison scholars of our time. So the thought that she would be a part of this event and be on this panel was just, that's the preemptive compliment. If you wear the prefatory compliment, always. But anyway, but I already knew that. And I will try to draw on her thought in working through Madison. And of course, I'll be curious to see if she thinks I've got her right or have got the implications right. Okay, let me just spend a little bit of time describing what I take to be Madison's trajectory and then how it might bear on these issues. There's a wonderful and what's your let me go back. There's a wonderful letter that Madison writes to Jefferson in I think it's October of 1788, in which Jefferson expressed his misgiving because the Constitution doesn't have a Bill of Rights. And Madison answers, and essentially his answer is that well, a Bill of Rights is very important as a check against the possible abuses of power of a monarchy. Because there, the political power is in one place, but the residual force of the community is in another. And what a Bill of Rights can do is to serve as a standard for rallying the residual force of the community. So if you have an unjust tyrant oppressing the people, if you have a Bill of Rights, it can help to mobilize the people to challenge the tyrant. But Madison explains to Jefferson, in a republic, a Bill of Rights is far less functional, because there you have combined the political authority and the residual force of the community. The real problem in a republic is tyranny of the majority. And a Bill of Rights is not going to be very useful as a standard for rallying the residual force of the community. As Ronald Reagan might have said, the majority is not the solution, the majority is the problem. So Madison suggests, I don't find it at all urgent to have a Bill of Rights in a republic. But then as a kind of throwaway said, well, there may be occasions when the problem is a minority faction controlling government and oppressing the people, then it might be useful. And in any event, it can help educate the public so that it can have a good effect there. But these are kind of minor contingencies or effects, so it's just not that important. But I thought that it can't do any harm, and some people want it, so I'll go ahead and write a First Amendment, get it passed, and so that was basically his attitude, that the freedom of speech was just not that important. What was really important was the system of checks and balances, setting up a system in which ambition would counter ambition, and which power would be divided, and the like. His strategy for protecting rights was largely separation of powers, checks and balances, federalism. And now what Professor Sheehan has taught me is that he always, even from the beginning, thought that public opinion had a role to play. And so the way I just stated it is crude and overstated, but I would still maintain that his emphasis changed somewhat as the years went by, and that in the late 1780s, while he thought ultimately public opinion was important as a check, and said that at the time of framing and ratification struggles, that he placed more faith on these that, that in the early 1790s, in the first years of the administration, Alexander Hamilton was Secretary of the Treasury, as you know, and had a vision for the country, hoping to turn it into a world power and a commercial republic. And Hamilton had a very carefully thought out plan for advancing this kind of identity for the country with various proposals for retiring the revolutionary debt, or not funding the revolutionary debt, so there would be an ongoing debt, subsidizing manufacturing, setting up a Bank of the United States, an aggressive policy to try to open up trade with England. And part of Hamilton's strategy, actually, was giving the financial interests, the powerful financial interests, a real stake in the federal government. He thought that the ability of the federal government to survive and flourish, what would make republicanism really work was having this constituency of people who had a stake in the government, a financial stake. This greatly alarmed Madison and caused his split with Hamilton and caused him to begin to wonder whether the system of checks and balances that he had set up would be as effective as he thought it would be. He began to think that, essentially, boy, this guy Hamilton has really found a way to use the various carrots and sticks, financial carrots and sticks, and the various powers of the executive branch to put it crudely, buy off legislators. And there isn't quite the separation of powers effect that he hoped for, and to create a class of political actors with great power at the seat of government that is really a threat to Madison's ideal of what a republic should be all about. Professor Sheehan describes this wonderfully well in a passage I have to share with you. At the legendary dinner hosted by Jefferson and attended by John Adams and Alexander Hamilton in 1791, Hamilton once again demonstrated how audacious he could be. In response to Adams' pedantic remarks on the near perfection of the British Constitution, which, he said, needed only to be purged of its corruption and equality of representation established in its popular branch, Hamilton's riposte must have tested the bounds of his host's civility. Purge it of its corruption and give to its popular branch equality of representation, Hamilton reportedly said, and it would become an impracticable government. As it stands at present, with all its supposed defects, it is the most perfect government which ever existed. Almost certainly Jefferson's good Madeira was flowing at the table that spring evening, and just as surely Jefferson repeated Hamilton's provocative remarks to his friend Madison the next time they talked. So that Madison became very concerned about the role of stock jobbers, of money interests at the seat of the federal government. What to do? Well, to make a very rich, subtle, long story short, one thing he decided to do was to engage more than he had previously in grassroots political mobilization. He began to think that the power of public opinion is going to be a more important check than he thought. He always thought it was a residual check, but that he began to think that the capacity to mobilize the general public was going to be more important than he thought. The way he viewed it, I think, he thought Hamilton had pulled off the trick of gaining control of the government for a minority faction, his financial interests. So, light bulb goes off. Gee, that was one of the reasons where a Bill of Rights could possibly be useful, and where the freedom of speech might be pretty important in being able to energize public opinion and rally, have a standard and sort of rally of Now, I think you can't understand Madison without really understanding the depth to which this concerned him and how important this was in the development of his political thought. One thing I've always admired about Madison is how empirical how empirical he was and how willing he was to change his mind. There are people who disagree about that, and I'd be very interested in what Professor Sheehan, who knows 10 times as much about Madison as I do, thinks. But he was a great student of the Scottish Enlightenment. He thought there were lessons to be learned from the intensive study of history. He thought that reflecting on one's experience was an important source of wisdom. He was less locked into his ideas than I think most big thinkers are. And so I think there was a kind of evolution in his thought in this way from his experience in the 1790s of watching Hamilton pull off what he pulled off and watching the way he saw the country developing. But and it led him just to reflect more and read more about the nature of Republican government. And one thing he did is to write a series of newspaper essays in 1791 and 1792, which can be read as elaborations and significant elaborations on some of the ideas he put forth in the Federalist Papers. And indeed, Professor Sheehan, I think, was the first to really systematically analyze they're called the Party Press essays published in the National Gazette in 1791-92. And I think for trying to understand how Madison may have evolved in his thinking about the role of freedom of the press and the First Amendment generally, I think these Party Press essays are very valuable. I won't go into all of them. If I had more time, I would, but or others. But the one I want to emphasize is called Spirit of Governments. And essentially, this is something of a long quote, but you can't quote Madison on September 17th. When can you quote him, right? In Philadelphia, no. He tries to improve on Montesquieu and come up with a richer tripartite division of types of governments. And he thinks there are three types of governments. First, a government operating by a permanent military force, which at once maintains the government and is maintained by it, which is at once the cause of burdens on the people and of submission in the people to their burdens. Such have been the governments under which human nature has grown through every age. Such are the governments which still oppress it in almost every country of Europe, the quarter of the globe which calls itself the pattern of civilization and the pride of humanity. That's one type of government. Second type of government. A government operating by corrupt influence, substituting the motive of private interest in place of public duty, converting its pecuniary dispensations into bounties to favorites, or bribes to opponents, accommodating its measures to the avidity of a part of the nation instead of the benefit of the whole. In a word, enlisting an army of interested partisans whose tongues, whose pens, whose intrigues, and whose active combinations, by supplying the terror of the sword, may support, by supplying the terror of the sword, may support a real domination of the few under an apparent liberty of the many. Such a government, wherever to be found, is an impostor. It is happy for the New World that it is not on the west side of the Atlantic. It will be both happy and honorable for the United States if they never descend to mimic the costly pageantry of its form, nor betray themselves into the venal spirit of its administration. The third type of government. A government deriving its energy from the will of the society and operating by the reason of its measures on the understanding and interest of the society. Such is the government for which philosophy has been searching and humanity been sighing from the most remote ages. Such are the republican governments which it is the glory of America to have invented, and her unrivaled happiness to possess. May her glory be completed by every improvement on the theory which experience may teach, and her happiness be perpetuated by a system of administration corresponding with the purity of the theory. Now, obviously, this sounds all very lofty and general, but it's aimed at Hamilton. And I'm sure he is accusing Hamilton of preferring some combination of one and two, whereas what he takes the Constitution and the meaning of the revolution to be is the attempt to set up a third kind of government. Now, the third era in which, and I think that this is all part of an important moment in the evolution of his thought, again, increasing the importance of making sure that the general public is not sold out by the special interests, essentially. Now, the third major era in his thought is 1800, and it's surrounding the dispute over the Sedition Act of 1798, part of the Alien and Sedition laws. And that was the occasion in which Madison developed his most detailed, most systematic constitutional interpretation of what exactly does the First Amendment mean, because he claimed that the Sedition Act of 1798, which was a violation of the First Amendment. And what I think is most revealing about his argument is how much he bases his claim that the Act is unconstitutional on his extended argument, about half of the whole section about freedom of the press, and the claim that what the freedom of the press is most important, what it's mainly about, is it's the instrument for safeguarding the fundamental right, which is the right of citizens to freely examine public characters and measures and to communicate with fellow citizens about that. That is, it's part of the system of checks and balances. That the function of the First Amendment is to keep government honest and to identify abuses of authority, violations of rights. You know, the ultimate right is the right of freely examining public characters and measures. And I think that that is quite significant in bringing us back to how Madison, he was a wonderfully, I think, synthetic thinker, that he still is thinking checks and balances, but he has now come to see how mobilizing public opinion is a very important part of the system of checks and balances, in a way that was implicit or even more than implicit, but not as much emphasized in his earlier thought. Now back to Citizens United. What does all this have to do with Citizens United? Well, he does clearly believe, Madison, that speech about elections is the core of the First Amendment, because he views elections as the most important events in this checking process. That's where citizens really do their checking. So he fully agreed with the majority and the dissent in thinking that elections are so important. Now, he does think it's important that elections not be tilted. That one of his strong arguments against the Sedition Act, it was pro-incumbent, because it only punished criticism of incumbent officials and not of their challengers. So it discouraged speech critical of incumbents and didn't discourage speech critical of challengers. On its face, it was discriminatory and pro-incumbent. Now, would he say that it matters a lot whether a particular law is pro-incumbent or not? I think he would. I think that would be very important to him in the way he looked at the First Amendment. Would he only worry about that if it was on its face rather than in effect? I doubt it. My sense is that he was a person who, he was an instrumentalist in modern parlance. He cared about results. And if he thought that the law was working in a way to protect incumbents, he would have thought that is a very important reason to strike it down under the First Amendment. Now, I don't think the majority disagrees with that. I don't think the dissent in Citizens United disagrees about that. What it does suggest is it really matters what you think or what a disinterested, well-informed observer thinks about what is the case with corporate and union spending. Is it likely to protect incumbents, or is it likely to make them accountable and more vulnerable. I would argue, and Stevens argues this at great length, that follow the money. But there are ways in which you might think that one of the arguments on the other side is that yes, incumbents spend more money, yes, incumbents raise more money, but challengers need more money and use more money more effectively. And to mount a viable challenge, you need to really be able to have ways of getting a lot of money, and that sometimes that can come from corporate treasuries or union treasuries. Prior restraint. Would Madison think that PACs amount to effectively a prior restraint? I think he would. I think he would agree with the majority on that. I think he thought the Sedition Act was not different, really, from the licensing of the Tudor-Stuart period. Different in form, but similar in effect. Very discouraging of speech. So if you think PAC regulations are quite discouraging of speech, Madison would think they would be entitled then to a very strong adverse presumption, effective prior restraints. He wasn't a formalist in trying to decide what's a prior restraint. What would he think about speaker identity discrimination? Would he find that kind of a principle in the First Amendment? He was more of an egalitarian than most people realize. He thought at least equal civic status was an extremely important notion. That goes all the way back to his original interest in freedom of religion and his famous memorial in Remonstrance. These party press essays have some very interesting things to say about the importance of political equality. Would he think that the equality between ordinary citizens and corporations and unions was an important part of that? I have my doubts. Stevens and others argue that these are artificial creations. They're created to serve certain social purposes. They're not rights-bearing natural citizens. They don't have natural rights. They don't vote. They can't. But, and here's, I think, where he gets to another point, which is they can inform people who are rights-bearing citizens, ordinary voters. That is, the majority says, don't look so much at, the majority does make claims about let's treat corporations equally with citizens, which I think Madison would not have embraced. But they also says, the real rights holders here are the listeners. And if all this corporate and union speech creates more speech, that helps all listeners. Would Madison agree with that? Well, more generally, would he embrace the current important principle, more is always better? I think it's a pretty tricky question. That is, he did think political mobilization was important, Madison. He did think that there was to the degree that more speech engages more citizens, gives them more resources. I don't think he thought that proliferating factions was an end in itself. That some people who've read Federalist tend to say, it's kind of all cancel each other out, and true wisdom will have room to operate. And that's, I think, the interpretation of Federalist 10 has been pretty thoroughly discredited. There are factions and then there are factions. So I don't have time to really go into this, but my own bottom line is that I think that that while it's possible that he would have given a fair amount of weight to the more speech is better than less speech, I don't think to the same degree that modern First Amendment doctrine, in a kind of one-dimensional way, more is always better, does. I think he would care also about the distribution and about the quality of the speech. Ultimately, I think he would think the most important consideration really is what does it do to the quality of civic participation? It's very important that citizens feel a part of their government and are genuinely empowered. And so then it becomes, once again, as I think he would approve, an empirical question. What do we think the effect of the freedom now of corporations and unions to spend their treasury funds, what does that really do to the experience of ordinary citizens in terms of their relationship, both to the process, the electoral process? Do they feel just insignificant? And indeed, he talks in these party press essays about a government can get too big. Everyone assumed that he's most famous with the extended sphere, small government, allows majority faction to oppress, big government multiplies faction. But it could get too big to the point where citizens feel insignificant. So he'd worry about citizens feeling insignificant. Do they feel insignificant because of all this corporate union money in the process now? If so, he would worry, I think, about that. Also, the relationship to one's representative. He thought it was very important that citizens believe that they actually have a voice that's heard by their representative and some control over their representative. And one of the worries I have, at least, about adding a lot more money to the system is that representatives are going to spend even more time now, if that's possible, attending to fundraising and attending to building up reward checks, for fear that at the 11th hour, a lot of union or corporate money could come in and really blindside them. So that it's just prudent contingency planning. And to the degree that representatives are spending their time raising money, they're not spending their time servicing constituents, hearing the concerns of constituents, doing the work in the legislative process for their constituents. So I think if that is an effect of this opinion, then I think that also would be a pretty important challenge to Madison's conception of republicanism.
We'll now hear a reply from Villanova's own Colleen Sheehan. Move the microphone.
Can everyone hear me? If you can't signal, then I will I'll speak louder. First of all, I want to thank Vince for being here and for writing such lively, articulate, crisp, thoughtful remarks on this subject. But before I go there, I want to thank Rob Miller, who has done everything to make this conference the wonderful success that it is, and I am so grateful to have him on board as a partner in crime at the Ryan Center. So thank you very much. And if I might thank my colleagues across the tracks, I'm of course over in Baja, Villanova, for welcoming the Ryan Center at the law school. We're really looking forward to a long and good and productive relationship between both sides of Villanova as we think through these kinds of issues. So thanks very much to the law school professor and students as well. There is so much to commend in Professor Blasi's description, and there I'm going. There's the praise, so where's the other shoe going to drop? But one of the things that I particularly appreciate about the work that you're doing is that the general interpretation of Madison for eons, certainly since Charles Beard in the early part of the 20th century, and then beyond that with people like Martin Diamond and so forth, is that, well, Madison's kind of he's a pluralist. He's an aristocrat, or he's a pluralist, or he wants a multiplicity of factions. Either way, the most that you get out of Madison is a kind of negative liberty. He wants to prevent injustice. And injustice is in a very limited sense. It's not at all in the classical sense of, or what Benjamin Constant might call an active idea of liberty. But Professor Blasi has pointed out very, very well that Madison cared deeply about civic education. He cared about responsible and participatory citizenry. It was absolutely critical to his thought, and these party press essays help point this out. By the way, that second category in spirit of governments, that's the British government. And so, yeah, you're absolutely right. He is really he's going partly at Montesquieu, who thinks the British government is a model, but also, of course, at Hamilton and Adams. The title business there is directed at Adams, though he never mentions any names like that at all in these essays. And so, Madison is a founder who had a vision of popular government representative democracy that is much broader, much fuller, much more flourishing in terms of questions of justice and the general good than he has been given credit for. And today's the appropriate day, I think, to remind ourselves that the person we call the father of the Constitution was thinking way beyond the years in which he wrote, and thinking of, I suppose the best way to encapsulate what Madison cared about most of all, what his life's project was the project, the experiment in trying to make successful the trial of self-government. And so that required that citizens, not just then, but every generation, each one of us that is a citizen of this country, it's of course a process that starts anew to understand the principles, the rights and responsibilities of a Republican, small r Republican citizen, and to learn and take upon ourselves the habits of self-government. And so I appreciate so much that people in other fields are working on these kinds of things, because generally the interpretation of Madison has been just the opposite of that. It's been pretty vacuous. He wouldn't have recognized himself in the interpretations that have been dominant for many years. Having said that, I think there are maybe a couple difficulties with Professor Blasi's interpretation of Madison, because essentially, if I can put it this way, I think it's a projection of a consequentialist jurisprudence onto Madison, which I think Madison would very much reject. Professor Blasi's concerns are real. And there's, I think, an idiosyncratic kind of moral reading of the Constitution that's at the base, perhaps, of your concerns. And if I can paraphrase Ronald Dworkin, this moral reading of the Constitution is concealed behind the claim, quote, Madison made me do it. Well, so I think the result of this is that in the name of, if I understood Professor Blasi correctly, you believe that the chief function of the First Amendment is essentially to control, perhaps correct, the abuses of government because of Madison's statement in the report of 1800. That one of the roles of free speech is to examine characters and measures, right, of government as a way to control the abuses of government. And that certainly is one of the results of free speech, or a possible result. Is that the chief function of the First Amendment, to control the abuses of government? And then as a solution to that, to control the abuses of government, to have government decide who should speak, when they can speak, and how much they can speak, so that their abuses will be controlled. I'm a little bit afraid that that's really the fox in the henhouse. But let me take a few points of consideration. Is there a need, from Madison's perspective, to treat all speakers the same? Professor Blasi thinks no. Particularly because of this distinction, not just looking at quantity of speech, but quality of speech. Some speakers, and the opinions that they're voicing, are backing interests that are detrimental to the country and contrary to justice and the public good. In other words, factions, contrary to the rights of individuals or to the permanent and aggregate interests of the community. So would Madison then want to make those distinctions among salutary speech and its opposite? I think not, and I think he's very clear on this in Federalist 10. In Federalist 10, he says, there's two ways to control the problem of faction. One is to remove the causes, the other is to control the effects. How do you remove the causes? There's two ways to do that. One is to destroy liberty. Because without liberty, there can be no factions. Liberty is to faction as air is to fire. If you want to get rid of the problem of fire, destroy air. There can be no more fire. But of course, the cure is worse than the disease. So Madison absolutely clearly rejects that remedy. And instead says, well, what we have to do is extend the territory. Extend in the sense of republics were generally thought throughout the history of the world that you have to keep them small, the classics and so on. Many of the anti-federalists read Montesquieu as making that argument. Says Madison turns it on its head. He says, no, extend the republic, and then you encompass a greater number and variety of interests and religious sects. Not necessarily just factions, because not all interests are factions. And in that you have this competition going on, and so it's harder to form a majority faction. But once you've got this larger territory, the people can't meet in one place, so then you've got to institute the principle of representation. Once you institute the principle of representation, you've created a government that's not the same as the people. Now you've got to control the government. So you've got to control majority faction, and now you've got to control minority faction, and the possibility of that in the government. So you get to Federalist 51, you have separation of powers, checks and balances, bicameralism, federalism. But, he says, these are inventions of prudence, auxiliary precautions, because the primary control on the government is the people. Those are, he makes that argument absolutely explicit. I'm already running out of time. This is, I love the phrase you use, satisfaction of an intellectual groupie, and I think I want to join this group because it's just an amazing thing, isn't it, to be able to teach and to work on the things that you love. Who thought of this idea? Not a lot, but even anything is really acceptable.
Speak for yourself.
In terms of, I think I'll skip incumbents versus challengers. I think Madison would think that you probably shouldn't really try to favor either. Quantity versus qualitative, quantitative versus qualitative speech. It's absolutely true that Madison's concerned with the quality of public decision making, and that he wants to refine and enlarge the public views. But it's not clear at all to me that that he would want to then limit speech in any way because it's of lesser quality. I mean, I think that's the argument in Federalist 10, that you can't destroy liberty because of the problems of fashion. What about the idea of if politicians engage less in fundraising, that they'll engage more in lawmaking and perhaps studying the issues that are brought before them and so on? I was in politics for a short time, and I have a news flash. That's not going to happen for most of them. They're just going to play more golf. So I don't think there's a corollary necessarily between spending less time fundraising and being a more responsible representative. I wish there were. Well, I have lots more that I'd like to contribute, but let me just perhaps cite a couple things from Madison. Madison said, public opinion sets bounds to every government and is a real sovereign and every free one. Opinions are not, he said on June 8, 1789, on the floor of the Congress, opinions are not the object of legislation. The censorial power is in the people over government, not in the government over the people. Once you extend this territory and you've made it more difficult for a majority faction to form, what that means is it's more difficult to communicate and build a coalition. It's harder to communicate over a larger swath of territory. Now, the change in means and improvements in communication have changed that, right? Especially not just the telephone now, but the internet. But he recognized that improvements in communication is equivalent to a contraction of the territorial limits. But once you do that, you've made it more difficult for a majority faction to form. But he still wants a just majority to form and to rule. And what is absolutely critical in that is communication. What is it that we communicate? Ideas. How do we communicate? Through language, through various forms of speech, oral and written. So Madison is very clear, I think, throughout his writings that free speech should not be encumbered, should not be abridged, and that's absolutely essential to his vision of republicanism. Thank you.
Before taking questions from the floor, I'd ask the question of the significance that it's the director of the Ryan Center who alone has transgressed time limits on this first half of Constitution Day.
So much for self-government.
Exactly.
Two maybe arcane points about Madison, and one a more simple-minded and bombastic point about Citizens United that I'd like to respond to. First, I really have to say that at least in 1787 and 88, James Madison really did not want a Bill of Rights. He saw it as an entering wedge for men like Patrick Henry, the leader of the 18th century Tea Party, to strip the powers of the federal government. So he was a reluctant convert to the need for a federal Bill of Rights. The one amendment, when he had to do it, he actually took the leadership in drafting a Bill of Rights, but the one amendment that he wanted most of all in that Bill of Rights, which was an amendment that says the state government shall not abridge freedom of speech, religion, et cetera, et cetera. And he lost that one. It was deleted from the final version in the Senate. The second point, it does seem to me if there was one fundamental liberty which Madison cared most about, it was not speech and press. It really was free exercise of religion. That was what he saw as the greatest threat to liberty. He saw that threat coming from the individual states. My bombastic comment is, it's money, not speech. And if you're a textualist, it doesn't say Congress shall make no law abridging the right to give boatloads of money to political campaigns. And here I agree with Professor Blasey. I think Madison, at least the more partisan James Madison in the 1790s, as he really feared that Alexander Hamilton was in the lead to give primacy to concentrations of money and power in the body politic, that I think Madison would have had some real reservations about a sort of blanket guarantee of free speech to groups like the ones that Hamilton was representing.
If I could respond to that, and also to what Professor Sheehan said. In some ways, inevitably, we can't avoid a kind of anachronism problem, which is we tend to think of the meaning of the First Amendment as how courts should properly interpret it in cases. But what justices come up with in trying to get meaning to the First Amendment for that purpose has a huge overlay of legal theory, of having to come up with doctrines and ideas and rules of thumb and reasons that can't count, because you need to administer a system of many layers. You have to give notice to litigants and so that it may well be that take, for example, the principle the court has taken as its just mantra in all these cases, quoted again in Citizens United: the concept that government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment. Now, that's based on notions of institutional distrust. It's based on certain kinds of considerations about how courts need to understand the First Amendment, because those who say you should be able to keep some voices from drowning out other voices, they want more speech. They want citizens in a larger nation to be able to be heard, and they think they can't be heard because they're drowned out by just the 30-second attack ads financed by big money. So it's not enough to say, we want more speech, to say then you can't start regulating this corporate speech. But you may think there are additional considerations of institutional distrust and how legal doctrine can't be instrumentalist in a way that politicians can be instrumentalists in trying to apply the First Amendment. So all we know from Madison's writing is what he thought a person ought to do in interpreting the First Amendment for the purpose of acting in the Virginia legislature or in Congress. We don't know what he would have done if the question was, what should a court do interpreting the First Amendment in a lawsuit? There may have been an overlay of formalism necessary to the legal process of the sort that I take it Professor Sheehan is invoking. That Madison might have said, yeah, I guess that's right. If we're doing law in courts, we've got to be more simple and less instrumentalist and more formalist. I don't think we know that. But I think we do know a fair amount about what he thought the First Amendment ought to mean, at least for the purpose of guiding the legislature. We have time for one more question. Matt.
Would Madison have considered corporations and expanding that to unions as persons with the individual right that you're giving, that we give them now, so that they can use corporate funds or union funds in financing rather than individual funds?
My short answer is I don't believe so, but I'd love to hear Professor Sheehan, who I think knows a great deal more about that. I do think that part of what he thought it meant to be a rights-bearing creature is to have some natural rights. I'm sure the corporations don't have that. Some rights he thought that rights bearers have rights because they are citizens that have a duty to govern. I don't think he would have thought corporations have such a duty. So I think the only way he would think corporations had rights would they'd be derivative rights to serve the interests of listeners who are citizens. And that's a kind of third level removed. But it'd be the weakest kind of right, I think, for that reason.
Well, I'm going to let the lawyers deal with this from the legalistic standpoint, but certainly recognize assemblies of individuals. And assemblies of individuals, groups, individuals still possess individual rights. And he does talk about certain kinds of groups as having the status of a moral person, and thus have also the responsibilities of a moral person. I could respond very briefly to your remark. The major reason Madison says he's opposed to the Bill of Rights originally is the same reason Hamilton gives and others, is that the Constitution is the Bill of Rights. That is, in England, the government grants rights to individuals. In the United States, the people grant power to the government. And Madison was concerned if you start listing rights, that there might be a presumption, who would have thought? I mean, this certainly hasn't happened today, right? There might be a presumption that those are the only rights that we possess. And so when he does go along with it, and says, well, let's do this very carefully. This is so important to so many people to bind our union back together under this. He makes a promise that he will do this. So the Ninth Amendment, don't presume that these are the only rights. But of course, many of our justices don't want to go near the Ninth Amendment. So that's incredibly important to Madison, is that we don't, it's not because he's afraid that this will take powers from the government, it's just the opposite. And the one thing he agrees with Jefferson on is, in terms of this communication and so on, is Jefferson puts it this way: truth is great, will prevail if left towards actual weaponry. Free argument and debate, error ceasing to be dangerous when opinions are left free to combat them. And I think that's, the two of them are really genuinely good friends and agree fundamentally, I think, on this free speech issue.
Isn't it curious that the self-proclaimed textualists want to pretend the Ninth Amendment isn't there?
On that profound note, with the permission of our convener, we've gone over a few minutes, but he has not granted permission for us to start our keynote session late. So we will reconvene promptly at 11:45. Thanks to our speakers.